Welcome to all the participants joining this session on SPACs. Quick intro of the panelists before we deep dive into the SPACs. Uh, I am Nishith Joshipura and I head the private equity and M&A practice at NDA. I have been joined by my colleague Parul Jain, who heads our international tax practice, and Ashish Kabra, who heads our dispute resolution practice in Singapore. As all of you are aware, SPACs are the latest buzzword in the global capital markets. And with the announcement of the Renew Power Spak deal, the interest amongst the Indian businesses for Spak transaction have hit the roof. As all of you are aware, Renew Power is going to get listed on NASDAQ with a valuation of, with an enterprise value of $8.8 billion. With an enterprise value of $8 billion and market cap of $4.4 billion. We were fortunate enough to advise Renew Power on the legal and tax structuring and documentation for the SPAC deal. Let me quickly go through on what all points we are going to cover in today's session. We are going to cover 6 or 7 aspects related to the SPAC deal and the folding up of Indian businesses with the SPACs. We are going to cover how does a typical SPAC structure work. Then we'll be covering why is there so much of interest for SPACs amongst Indian businesses. We will also be covering what are the typical criteria to identify a SPAC target in India. Then we will cover the typical structures through which the Indian businesses can be acquired by SPAC. We will also be covering the legal and tax issues with respect to the folding up of Indian businesses in SPAC. Ashish will also cover the Dspac documentation, that is the documentation that's required for the SPAC to acquire Indian businesses. And we will touch upon the regulatory approvals that are required for the purpose of the SPAC transaction. So let me start with how does a typical SPAC structure work. A SPAC is a special purpose acquisition company, and which is also called in US a blank check company. What it means is that when a SPAC goes public, there is no business in the SPAC. So what happens is the investors invest based on the track record of the founders. And once they've invested the money, the founders typically have about 18 to 24 months to identify an acquisition target. Although as per SEC laws and NASDAQ rules, a period of 36 months is given for SPAC to identify a business combination. The market standard has been 18 to 24 months, and typically most of the prospectus of the SPAC, they adhere to this period of 18 to 24 months for identifying a business combination. Now, interestingly, what happens is from a cap structure perspective, SPAC typically issues 5 types of securities. The first security is what you call units. So these are called SPAC units. Now each SPAC unit is further divided into 4 parts. It could be a combination of Class A shares. The Class A shares are typically issued to public shareholders. Then there are Class B or Class F shares, which are issued to the founders. Then there are public warrants, which are issued to the public shareholders. And there are private warrants that are issued to the founders. Now, interestingly, the biggest advantage that the founders have in a SPAC deal is founders typically get 20% of the fully diluted capital of the SPAC against investment of $25,000 in the SPAC. So assume a situation where it's a $500 million SPAC and founders are getting 20% of the share capital, which means just by investing $25,000 in SPAC, founders get $100 million worth of stock if the SPAC is able to successfully consummate the business combination. So there is a huge upside for the founders in a SPAC, and that is driving the craze of the SPAC currently in the global capital markets. Interestingly, in 2021, if we look at the numbers, in the first month itself, 131 SPACs got registered with SEC. which means in 31 days, 131, so on an average, almost 4.5 to 5 SPACs have got registered with SEC on a daily basis. And this shows the interest that the SPACs have generated for a period of time. Now, what happens to the cap structure? So once the founders file the registration statement with SEC, the units start getting traded on the exchange, which typically is NASDAQ. Most of the SPACs have got listed on NASDAQ because NYSE rules were a bit stringent, although NYSE also changed its rules in 2017 to make it easy for SPACs to get listed on NYSE, but still most of the SPACs are listed on NASDAQ. Now, what happens is once the units are listed, typically there is a gap of 52 days post the listing of the units, after which the units get split between shares and warrants. Now, typically one unit is equal to $10. And when the unit gets split between share and warrant, the Class A share is also of $10 face value. And the warrants are typically, they have a strike price of $11.50. And this is all based on the prospectuses that have been filed. And the benefit of warrants for the public shareholder is that they don't need to put in money on day one. As and when the business combination happens, depending on the price of the securities, if the price is more than $11.50 at the time when the business combination happens and the merged entity gets listed, then there is an upside for the public shareholders to exercise the warrants at $11.50, since they will get an upside. If let's say if it's $15, then $3.50 will become the gain for the public shareholders. Same thing for founders. Founders also have founder warrants where they invest about 1.51 or $1.50 in the founder warrants, and they can take the upside once the listing happens of the merged entity. Now, interestingly, the unit, as I mentioned, is equivalent to 1 share, or it could be half warrant or 1/3 warrant. That's the market for warrants in the US. And which means that if it's a 1/3 warrant and if you want a full warrant, then you need to acquire 3 units. 3 units will be equivalent to 3 Class A shares and 1 warrant. And only a fully paid up warrant is tradable. Now, this is how a typical SPAC cap structure works. And as I mentioned, what happens is that the Class A shares and public warrants are for public shareholders, and Class B shares or Class F shares and founder warrants are for the founders. Now, what happens in a situation where the founders are able to identify a business combination? The process that has to be followed is as follows. Within 18 to 24 months, when a business combination is identified by the founders, there is a requirement for the founders to adhere to 2 conditions. One is that the acquisition target has to be at least 80% of the value of the money sitting in the trust fund account. So whatever monies are raised from the public shareholders are kept in a trust account, which cannot be touched by the founders unless there is a business combination that has been identified, or if no business combination is identified within 18 to 24 months, then that money has to be returned back to the public shareholders. So what happens in this situation is that the founders have to go back to the public shareholders to take their approval for the business combination. Now, if the SPAC is in Cayman Islands, then as per Cayman Islands company law, more than 50% of the shareholders have to vote in favor of the business combination for it to be successful. So if more than 50% vote, then the business combination can go ahead and SPAC can acquire the target. Plus, as I mentioned, the 80% requirement also has to be satisfied, that the acquisition target has to be at least 80% of the funds sitting in the trust account, which have been contributed by public shareholders. Now, once this transaction happens, once these approvals are taken, right, then the business combination happens and there are certain filings that are required to be made with the SEC, right? Now, there is also a time lag between the signing of the Dspac documentation. Now, what is Dspac? Dspac means when a Spac identifies and consummates a business transaction, it is called a Dspac transaction. So what happens is, in a situation where there is a definitive documentation that is entered into between Spac and the target company and its shareholders, between that period of time and the actual closing of the transaction, there are certain proxy statements and forms that need to be filed with SEC with respect to the target. Because when the Spac first got listed, it was a company without any business. So SEC clears those type of filings very fast because there is no business in the company. But when the Dspac transaction happens, this is the time when the financials, assets, and details of the target company become relevant and important for SEC to look at. So it's kind of a re-IPO that happens of the Spac to the target, right? Where all the details have to be submitted. So overall, if you see within 4 to 5 months, right, from the conceptualization of the Spac transaction to consummation of Spac transaction, in 4 to 5 months, it is possible to consummate. Now, interestingly, along with all Spac transaction, there is always a pipe deal that is arranged by the founders. And the reason for that is that if there are certain shareholders who don't vote in favor of the Spac transaction, they have the right to get their money back, right? So let's take an example where out of 100%, 51% voted in favor and 49% did not vote in favor of the business combination. That 49%, those 49% shareholders have the right to get their money back. So what happens is, on one hand, the founders have already negotiated the deal with the target company's promoters and the shareholders to pay a certain price. But at the same time, they are not sure that after signing of the document, if majority of the investors in Spac ask for refund of money, they will not be able to close the transaction. Which is why, to take care of this contingency and uncertainty, there is always a pipe that is parallelly arranged by the founders, so that even if there is a refund of money that the Spac has to do to the public shareholders, the pipe money takes care of the deal value and the transaction can be consummated based on that. So this is how typically a Spac structure works. This is how the cap structure of a Spac works. This is how a Dspac structure works. Now, the question which keeps coming up from various promoters of Indian companies and P investors since the time the Renew deal has been announced is, why have Spacs become so popular in India now, right? Because in the US, Spacs have been there since early 90s. It's not something which is a new kid on the block, right? It's more than 3 decades the Spacs have been there. But why the Spacs have become popular for Indian businesses is for the following reasons. One is, for an Indian company with Indian business, what are the options that the Indian business has to list itself, right? The first and the simplest option is to list on Indian exchanges, right? But the value which a foreign exchange gives for some of the Indian businesses, the Indian investors are not able to give that value, right? So just listing shares on Indian businesses does not help always. Second important point is, you can do an ADR listing on NASDAQ or NYSE for Indian business, but as per the Indian laws, only when the Indian company is listed in India, you can issue ADRs, GDRs, right? And all the tax laws and other laws are worded in a manner where it is feasible only for Indian listed companies to do ADRs, GDRs. So that option is also not there. The third option, which the government is mulling over since last March 2020, is to allow direct listing of Indian company shares on foreign exchanges, right? Now, this is obviously going to be a game changer. However, it's almost more than a year since March 2020, and the government hasn't come up with the detailed rules on some of these concepts of how to list overseas, how would SEBI laws work, how would tax laws work, how would foreign exchange laws work. And this has been a problem since many years, where certain big announcements are made, but implementation of the announcement gets delayed. So just to give an example, in 2014, the 1993 ADR GDR scheme was repealed, and the government allowed even ADR, GDR issuances on unlisted shares of Indian company. For 5 years, nothing happened. SEBI was supposed to come back on that. For 5 years, nothing happened, and SEBI came back in 2019 in October and said that only listed shares can be used for the purpose of issuing ADR, GDR. So we are again back to square one, what we were in 1993. Same thing is happening again, where in March 2020, the announcement was made for direct listing of Indian shares. And after 1 year, we still don't have any regulations. Now, these are the three avenues that I mentioned for listing of Indian businesses, which have not worked. And that is where the SPACs are becoming very, very popular. And interestingly, we are talking with the heads of one of the PE funds. And what he mentioned is that they did a SPAC transaction for one of their US portfolio companies. Just 2 months before the SPAC transaction, the last round, pre-IPO round that happened in that company was, let's say, at X valuation. In 2 months' time, they managed to list the SPAC and the shares at 3X valuation. And within 6 months to 12 months' time, the valuation of SPAC multiplied by 5 times. So compared to the pre-IPO round, the valuation of the SPAC is 15 times. And that is the biggest kicker as far as the SPAC is concerned, where the valuations provided by the US investors specifically for some of these businesses is much better than the valuation with the Indian investors would provide. Now, from a US perspective also, if we see choice between a traditional IPO versus choice between a SPAC, what we are seeing is SPACs are clearly the flavor of the season, and the number of SPACs compared to number of traditional IPOs is much higher compared to the data if you see in the previous years, right? And why this has happened? 2 or 3 reasons. One is because of the global pandemic, right? As of June 2020, the private equity funds had almost $1.45 trillion of dry powder, which they could not deploy because of the pandemic. So that money had to go find some way somewhere in the form of supply of capital. And SPACs were the first recipients of this capital from this private equity funds. The second major reason was the traditional IPOs for some of the large companies failed. Like WeWork is a classic example. In 2019, they tried for an IPO, but it failed. And now WeWork is looking at a SPAC transaction to go public, right? That's the second reason, because traditional IPOs, there is too much of market volatility, which was in the form of COVID and the US elections. So the IPO was becoming a big concern for some of the large companies, and which is where the SPAC became a very important exit route for the investors in the target businesses and for listing of some of those businesses. On top of that, some of the large private equity funds, they also set up SPACs, and like Blackstone, PPG, Apollo, and that also resulted in giving a boost to the SPACs. So clearly, as we can see, the SPACs are the flavor of the season, and we have been able to devise certain structures to make the SPACs work for Indian businesses, which Parul will discuss in detail. But before I go to Parul, I think one question that keeps coming up from Indian promoters and the investment bankers is, how do you identify whether a particular target in India is a SPAC target, right? Because not all targets are SPAC targets. So I think a couple of things that we have seen to identify SPAC targets is, one is, ideally, if the Indian company is held substantially by foreign shareholders, so let's say 70, 80 or 90% by foreign shareholders, and Indian shareholding is only 10 or 20%, then that's something that works quite well. Ideally, the SPACs should be owning more than 50% of Indian businesses or Indian company. Otherwise, there is a risk of the SPAC being categorized as investment company as per the US Investment Company Act of 1940. So it's advisable that SPACs own more than 50% in the Indian company. And the second important parameter for identifying a SPAC target is that these foreign shareholders who are owning more than, let's say, 50, 60 or 70, 80% in the Indian company, they should have invested in the Indian company prior to 31st of March 2017 through a treaty jurisdiction. So that even if they have to swap their shares in the Indian company with a foreign company, there is a tax exemption available as per the India-Mauritius or India-Singapore tax treaty. So these are the two main parameters for identifying SPAC targets. And let me now go back to Parul and ask her about what are the typical structures, Parul, that you have seen for folding Indian businesses into SPACs.
Yeah, thanks, Nishal. And welcome everyone to our webinar on SPACs. I think, this question with respect to what are the different structures that one can use for folding Indian companies into SPACs. This question is asked more often than not because India is a complex jurisdiction with a multiplicity of laws. You need to combine corporate law, foreign exchange control laws, securities laws, and as well as tax laws in order to determine what type of a structure may work. Nonetheless, there have been SPAC transactions that have taken place in the Indian context. Whether we talk about the latest Renew transaction, whether we talk about Yatra Online, there have also been some failed business consummations which have taken place in the past. And when you look at the overall, methodology of the manner in which these acquisitions have tried to take place, I think probably there are at least 5 such structures which are possible under the Indian context. When we divide these structures, into two parts, of course, Nishal talked about, a very typical foreign SPAC set up possibly in the Cayman Island or possibly in the United States of America, which is a blank check company and whose intent is to acquire a target, based, let's say, in India. When we look at the Indian regulations, of course, the first thing that comes to one's mind is that why can't one have a SPAC in India? And Nishal spoke about some of the issues with respect to, listing of an Indian company on a foreign stock exchange. But when we talk about the reverse methodology of an Indian listed SPAC, today, clearly, if we leave aside, the gift regulations, which have recently, which have come out, there is no clear regulatory framework for SPACs in India. If we talk about a SPAC to be set up in India, the main issue that seems to be is that since SPACs are shell companies and they don't really have, a business upfront, there is an issue from a company's law perspective where there is an object identification which cannot be met. And from a company law perspective, the registrar of company can remove a company name if it fails to commence its business within 1 year of operation. We talked about how a usual acquisition time frame could be, commercially up to 2 years of SPACs. So this makes it incumbent for, a SPAC to be formed in India. Even otherwise, listing of a SPAC in India is quite difficult because a SPAC may not be able to meet requirements with respect to track record of profits, net tangible assets, and so on and so forth. The listing norms may also not be satisfied. And so therefore, when we talk about, a SPAC in India, given the lack of a clear regulatory framework, an Indian SPAC definitely doesn't work for acquisition of an Indian company. However, having said that, very recently, there has been a new regime which has been announced by IFSCA. IFSCA is the authority for GIFT City. And as you know, most of you would know, GIFT City is a new jurisdiction. It's India's own financial services center, which has been set up under the aegis of the regulatory authority of IFSCA. Whereby India is developing its own financial jurisdiction for attracting foreign capital and by providing certain tax and regulatory benefits. When we talk about the GIFT City is it's a kind of a mid-shore jurisdiction whereby the entities or units which are set up in GIFT are treated as foreign persons from an Indian perspective, but from a tax perspective, they are treated as tax residents of India. There are a lot of tax benefits which have been given with respect to trading of shares of an entity in GIFT, but we can talk about that in more detail when we talk about specifically with respect to a SPAC being set up in the GIFT city. So, like I mentioned, there have been draft listing of securities regulations along with the consultation paper, which has been introduced. And under these draft gift, listing regulations, there are special regulations for SPAC. The good part is that the authorities are trying to mimic an offshore SPAC. So the commercial considerations which Nishil talked about with respect to keeping the funding amount in trust accounts, the time period within which the transaction needs to be consummated, all of them have been clearly provided in the draft listing regulations. There is a special chapter for special purpose acquisition companies, and these companies are eligible to raise capital through initial public offer of the securities on the stock exchange in the GIFT city. So there is a special stock exchange in the GIFT city, and this has been established as a subsidiary of the NSE and BSE, and so therefore it is possible for a foreign company to set up a SPAC in the GIFT city, which can list its securities on the stock exchange with the primary objective to effect a merger or an amalgamation of a target which may be situated in India. If we look at the different steps which may be involved in setting up of a SPAC in GIFT City, and this is again a very new regime. So therefore, there are a lot of benefits which have been provided to investors for establishing presence in GIFT City. The founders of the SPAC can set up the vehicle in GIFT City without any approvals, without any implications. This will be regarded as a person resident outside India. So therefore, there are absolutely no problems. When it comes to transferring of shares of an Indian company to the SPAC, to the extent that the shareholders of the Indian company are foreign persons, there will be a tax impact for them to transfer out shares of an Indian company to the GIFT SPAC unless and until they are eligible for any tax treaty benefit. In the alternative, or in addition, the Indian company could also be merged into the GIFT SPAC. And the benefit that comes from there is that since from a company law perspective and an Indian tax perspective, the GIFT company will be regarded to be an Indian person and covered under the Indian Companies Law as well as under the Income Tax Act for tax benefits. The merger would be akin to a merger of two domestic companies. So there are no complications with respect to companies law or with respect to tax law. However, since this is regarded as a person resident outside India, there would be requirement for an RBI approval depending on the manner in which this the transaction for the merger is being done. Nonetheless, when we compare to an outbound merger of an Indian company with a foreign SPAC, it's probably expected that the approval for a merger into a GIFT SPAC may be looked at upon, it may be easier to get, but nonetheless, this is an approval which may be required. The other benefit that comes in is that trading of shares of securities issued by a GIFT SPAC on a stock exchange of the GIFT City is completely tax exempt. So there's absolutely no tax which is payable once the Indian entity is folded up into the GIFT SPAC. In fact, there's also a tax holiday which is available for units which are set up in the GIFT City. So it seems that on an overall basis, even from an operational perspective, once the Dspac transaction happens, this could result even in a long-term tax benefit for the entity which is folded up into the GIFT SPAC. There is, however, this issue with respect to, the Indian founders. Now, Nishil spoke about how, the SPAC transaction takes place, and specifically in the Indian context. The tricky part always is with respect to the Indian promoters who are holding their shares in the Indian company, and how do they really swap their shares of the Indian company with the shares of a SPAC. And since we're talking about a gift SPAC here, since the SPAC is considered to be a person resident outside India, there could be regulatory issues, but Ashish is going to talk about more from the perspective of Indian promoters and how to resolve the situation with respect to making sure that Indian promoters are also, they are also able to get liquid stock, and they're not really, in an effective, tax effective, as well as a legally compliant manner. So when we look at the Indian law and we look at Indian SPACs, the gift SPAC is something which is a completely new structure, and it is something which is feasible. Of course, the listing then happens on the stock exchange in the gift city, which also means that the marketability of the security would need to be assessed by suitably by investment bankers. There could also be issues with respect to subscription to the shares by Indian residents, but that would be the case for any foreign structure. So therefore, the gift SPAC is something which at least takes away a lot of regulatory issues and hassles and restrictions which exist in case if one were to set up a SPAC outside the gift city, but within the domestic territory of India. When we talk about foreign structures, and if we talk about a very typical traditional SPAC structure, and the SPAC is set up outside India, the SPAC could be, let's say, in Cayman Island. A very simple structure could be that the SPAC simply acquires the shares of the Indian company. This could be a mix of a secondary deal, for foreign shareholders where they exit. And again, that's where they might need a treaty protection. Otherwise, they would be taxable when they sell shares of the Indian company. Otherwise, the foreign shareholders could also swap their shares for the Indian company, for shares of the foreign SPAC. In such a case also, since the transfer is taxable, they would be relying on the treaty protection, and they would ultimately be holding shares of the SPAC, which would be listed, and they would get liquidity directly at the SPAC level. The issue that comes in there is that even if foreign investors are holding shares of a foreign entity, which is listed outside India, but if the entity's value is being derived substantially from India, then there is a tax which is required to be paid at the time that they trade shares of the foreign entity. We don't really have a tax exemption for that right now, except in certain circumstances. For example, if because of pipe investors coming in or any other reason, the shareholding of the existing foreign investors is diluted to 5% or below, then they get a small shareholder exemption. Otherwise, if they're coming in from a suitable treaty jurisdiction, they might be able to get a treaty protection against indirect transfer tax in India. And if not, then at the time that they're trading the shares of the foreign SPAC, there is a tax that happens in India, and there are certain practical nuances also which get attracted with respect to, how do they really pay the tax in India? How do tax authorities practically even get to know with respect to the trading of the shares, and to what extent do India's extraterritorial laws apply to such type of transactions? In this case also, when we're talking about a foreign SPAC, which is simply holding shares of an Indian company, and the Indian company has not actually folded up into the SPAC, it's just acting and behaving like a holding company whose shares are listed. The other couple of issues that could arise is that if there are US investors, and purely from a US tax perspective, and of course, we are we are licensed to practice Indian law, But based on our discussions with certain US law firms on certain similar transactions, what we understand that if there is a foreign entity which is listed outside India, then it could possibly result in a dual taxation from a US tax perspective, because the US tax laws could tax the trade of the shares, but at the same time look through the Indian business, such that the SPAC would also pay tax in the US for its income from the Indian business on a look-through basis. There is again the question of how do you really give the founders liquidity, because they are holding shares in the Indian company, whereas the liquidity is at the SPAC level. And my colleague Ashish is going to talk about that a little bit more. The second step, to this SPAC transaction, now you could either leave this transaction as it is, the structure as it is, with the SPAC just being listed outside India and holding shares of an Indian company. But the other, further step could be that you actually fold up the Indian company into the foreign SPAC. Now, this results in certain complications where Indian laws are concerned. And so therefore, we've seen that many times SPACs that are set up, they're just, the structure is left as is with the Indian company continuing. The complications that could arise is that if an Indian company merges into a foreign SPAC, then that's an outbound merger, and for which an RBI approval would be required for certain aspects of the merger. The foreign SPAC could be regarded to have a branch in India. It may end up establishing a tax presence in India, and therefore, the tax rate that could apply could be much higher as compared to a tax rate of an Indian company. There is also no tax exemption for outbound mergers, and so hence, the moment an Indian company merges with a foreign SPAC, it's a complete taxable transaction for the investors, unless and until foreign investors have a treaty protection, and for Indian investors anyway, there would be a tax. It's a taxable event, and more so even for the Indian company for transfer of its assets to the foreign SPAC. Interestingly, our company's law actually permits foreign mergers subject to RBI approval. There are certain requirements with respect to the jurisdictional requirements and what type of companies, whether the jurisdiction is FATF compliant or in the grey list and so on and so forth. But subject to those, there are still these open questions with respect to taxability and with respect to RBI approvals. And hence, for a foreign SPAC, the structure which we've seen more often than not is that in case of a pure acquisition, the SPAC structure is left as is, with the holding company, with the SPAC holding the Indian company in India. The second structure from a foreign structure perspective could be with respect to companies which had actually externalized at the time that they were set up. And these are the likes of Make My Trip. We also saw, there was this SPAC transaction with respect to Yatra. And Yatra Online had also been acquired through a reverse merger into an acquisition corporation. The simple structure that could work there would be that companies that are already externalized at the time that the valuation is low and they could have done the externalization, rather than acquiring the shares of the Indian company, the SPAC would simply acquire shares of the holding company. Of course, tax issues could still arise because of indirect transfer issues, but again, depending on the treaty exemption. Subsequently, a merger of the two companies could be contemplated such that the SPAC ends up holding the Indian company directly, or the Indian company directly. And the merger of two foreign companies is also tax exempt in India, subject to satisfaction of certain conditions. So this is another structure that we have seen, but this again, the biggest question that is left open is, what about companies which are already set up in India, which are ripe for PIPE funding, or they've already received a late stage PE funding and they are contemplating exit through a SPAC structure? What do you really do with respect to such companies which have not externalized in their early days? And is there a way to really fold them up into a SPAC structure? So this is an interesting structure that can be considered, which is, you know, a kind of a third foreign structure. Um, Typically, we see that you know, the SPAC founders, they set up a SPAC in a jurisdiction like, let's say, Cayman Island. Uh, the the SPAC itself could be treated like a holding company. However, many times we have seen that jurisdictional comfort is extremely important. So therefore, what could be done is that the SPAC founders could set up a separate holding company in a jurisdiction which is comfortable for all types of investors. This holding company could then subsequently drop down a subsidiary to merge into the SPAC. And this is what we call a reverse triangular merger. Of course, you know, the need for dropping a subsidiary to merge into the SPAC could be, you know, it could be emanating from various jurisdictional tax issues, including the US or any other jurisdictions. But primarily, the holdco could drop down a subsidiary to merge into the SPAC, and through multiple swap transactions, one could get the SPAC investors to invest at the holdco level. Once you know, we've been able to get the SPAC investors at the holdco level, and you know, the investment which has been done by the SPAC investors into the SPAC, and you know, there's the cash which is currently lying in the trust account. That cash can then be transferred to the holding company and utilized for purchasing the shares of the Indian company. This would result in, you know, in a complete externalization of the Indian company in a manner that the holding company could then be regarded as either the new SPAC, or, you know, the holding company could then subsequently take in the PIPE investment and utilize that to acquire shares of the Indian company. Of course, you know, the important part here is that we are talking about acquisition of shares of an Indian company. And so therefore, for foreign investors, and most of the PE investors would probably be, you know, holding shares prior to 2017 coming in from treaty jurisdictions. We would have to rely on their treaty benefits. And they would subsequently obtain shares at the holding company level, at which point in time the business transfer would get consummated, and the SPAC would be put in place. I think a couple of points, and this is, you know, of course, there are a lot of multiple mini transactions which take place to come to the appropriate solution of a holding company which is invested into by the founder, the SPAC founders, as well as the SPAC investors and the PIPE investors, and subsequently holding the shares of the Indian company. But it does leave open again the question of the founder shares and how the founder shares need to be translated at the holdco level. And the other point that would also be done in the middle of all these transactions would also be, probably since the Indian company is in late stages of funding, to transfer out its employee stock option plan at the holding company level, which could again require a lot of tax and exchange control considerations. I think I'll just stop here because it's very clear that there are multiple nuances that one needs to look into. But Ashish, I think there's a lot of you know, a lot of questions keep getting asked with respect to, fine, we've come out with a way to solve the issue for foreign investors, but how do we really deal with the promoter shareholding, whether it's control, whether it's economics? Maybe, you know, you just want to touch upon those from a structuring and other perspective.
Sure. Thank you, Parul. That was a good summation of the tax and SPAC structures that you're looking at. Primarily, as I saw, it was falling in two brackets: Indian SPACs, which still are something for the future and not currently there, and foreign SPACs, something which already exists, which are searching for targets, and for which Indian companies can basically be the potential target now in future. And so now what we look at right now, at least for my part, is the second aspect, which is foreign SPACs looking at Indian targets and Indian targets looking to raise funds or go public via these foreign SPACs. Now, to the extent of the foreign shareholders in the Indian targets, Parul explained the various structures which are there. They have previously externalized, or they can externalize now. and sort of then go with that external structure, whether they be acquired by the foreign SPAC directly as a share acquisition, or there be a merger scenario where they set up a foreign parent, or drop down a subsidiary, which then merges, or does a reverse triangular merger with the SPAC. All of these are possible, but this is all there in context of the foreign shareholders. What about the Indian promoters, the Indian resident shareholders of the Indian target? They are holding shares in an Indian company. Even if the company had previously externalized, that externalization would not have typically resulted in them holding shares in the foreign parent. And when the SPAC when the Indian target gets acquired by the SPAC, the idea is that the value is derived from the foreign listing of the particular SPAC, and that the Indian shareholders also benefit from that particular listing and get value thereof. And consequently, the best way would have been the Indian shareholders to directly hold shares of that SPAC or the listed holdco or the offshore entity which is there. However, there are certain restrictions, and Indian shareholders or Indian residents cannot directly hold shares of an offshore entity. And these restrictions are basically arising from the exchange control laws. First is under the Overseas Direct Investment Regulations, which basically restricts an Indian party from acquiring or investing in a foreign entity that has direct or indirect investments in India. And second, under the LRS scheme, where even resident individuals who typically have a limit of up to 250,000 to remit each year, they are also restricted from investing, or rather they can only invest in an operating company, and such operating company or investee company cannot have any step down subsidiary. This effectively means that if an Indian shareholder cannot hold the shares of an offshore SPAC, which will then in turn be holding shares of the Indian target. And therefore, which creates an issue as to how do you then get value? The Indian resident shareholder cannot directly hold shares of the SPAC, and which is where the listing or the value is being derived. So the structure which is normally adopted, and is something which has been seen in the past as well in cases of externalization, is that you enter into a put option agreement. The Indian shareholder enters into this agreement with the offshore parent, the offshore SPAC, or whatever the listed entity is eventually. Under that agreement, the listed entity will be obligated to, or whichever way it's negotiated in that sense, but pursuant to that agreement, the offshore parent would agree to buy the shares of the Indian target, or the shares of the Indian target held by the Indian resident shareholders at a specified price. Now, this specified price would match the trading price of those shares. Effectively, what it means is that the Indian shareholders, as and when they want to liquidate their shares, they can put these shares in the offshore parent, which means that the shareholding remains, only greater consolidation happens because it improves the SPAC's shareholding in the Indian target goes up. So it's only improving the consolidation. And the Indian shareholder gets the exact value which it would have derived had the SPAC, it had directly held shares in the offshore SPAC and sold it on the public market, because that is the value at which the offshore parent would buy the shares from the Indian resident shareholder. So this is a way in which, even though today, because of the exchange control regulations, you cannot directly hold shares of the SPAC, but you can enter into this option agreement, effectively meaning that you can derive value as in when you feel like you want to sell these shares and get your money out, you can get the same value by selling it to offshore parent. Obviously, the parent requires to spend some money to purchase these shares. These funds can be sort of raised in various ways. It can be seen and sort of, you can commercially determine it. One of the ways it could also be a primary issuance by the SPAC of further shares to the public or otherwise, which could be a way to sort of get money into the SPAC, which then buys out the Indian shareholders as and when they put these shares on the SPAC. Now I keep saying SPAC, but essentially this would happen after this Dspac. So this is at that time a listed entity with an operating subsidiary. So this is a basic way which has been derived, at least on the economic side, that the resident shareholders can still continue to ensure that their value is also derived through this particular SPAC transaction. In terms of voting and control, well, there are multiple structures and ways around it. It depends upon each fact-based situation. At this stage, given the time constraints, I won't go into it. But yes, through voting agreements, through golden share arrangements, through other means, there are multiple areas which can be explored to effectively ensure that the Indian shareholders can get their rights or can exercise their voting rights at a stage or at the level where all the decision making is now sought to be consolidated. Eventually, if there is a holdco with foreign shareholders, idea is that the decision making be take place at one level, and preferably then it would be the offshore level. With that, I think I'll sort of rest here. I know we also need to discuss, and probably I can then directly move on, unless Nishchal, you have any comments here. I can directly then move on into typical documents which we see in a SPAC transaction.
Yeah, I think that would be helpful to discuss on what are the typical documents for a Dspac transaction.
Sure. So exactly. So I was trying to clarify that first thing, that what we will discuss right now is documents involved in a Dspac. Currently, we are not going into the SPAC because, as we see, Indian SPACs are something in the future, not in the present. So what we are looking at is a foreign SPAC looking at an Indian target. And therefore, what we look at and try and see, at least today for our discussions, we'll focus on other documents involved in a Dspac transaction, as what we say. That is, the SPAC no longer remaining an acquisition company, but rather the acquisition taking place. So its status of an acquisition company goes away, and it's now have acquired a company. So the documents that we see in the first one is, and this is the main mother document or the principal document, is the business combination agreement. Now, as others were using, Nishchal and Parul were using this term earlier, business combination is essentially, the idea is that it is combining the business or the target with the SPAC. Now, this could take many forms. It depends upon the structure that you adopt. It could be a share purchase agreement. It could involve steps related to merger if the structure is involving a merger. So it depends purely upon the various structures that we discussed earlier, which structure you adopt. But this is the main mother agreement. Obviously, this is akin to also like acquiring shares or acquiring a target. So if you want to draw certain parallels, though that could be a close parallel to what would you normally see in those agreements, would also be here in this particular business combination agreement. This will also document what happens to the rights of the SPAC shareholders or the unit holders, what happens to their units, how do they convert, and all of those aspects would also be captured in this particular business combination agreement. So this is the principal framework agreement, which will cover everything. The other agreement would be a shareholders agreement. Obviously, the foreign investors or the target had certain shareholders in the Indian target, who obviously, if there are foreign investors and other investors in the Indian target, they must have a shareholders agreement. Now, this would no longer be the entity where they would be conducting or would be voting at. They would be want to move this arrangement to the offshore level where everybody is now coming in at. So you will have a shareholders agreement between the shareholders of the offshore listco or the SPAC, which will basically govern post the Dspac transaction, how that company or how their shareholders would exercise their voting rights and how that governance of the company would work. So then you have the holdco or the offshore company's shareholders agreement. You will also have a voting agreement. Effectively, as we just discussed, the Indian resident shareholders cannot flip their shareholding into the offshore listco or holdco. Given that they cannot flip, there may be other shareholders who may not be flipping for various reasons. This could be tax reasons primarily though. But if there are other shareholders who are also not flipping and may decide to flip later or at whichever stage or work through an option agreement, then you also need to see how do you sort of govern their voting, because you typically want the voting to be consolidated at one particular level. So then you generally enter into voting agreements to ensure that the voting arrangement that you want is there. So let's say if the voting is consolidated at the holdco level, then those arrangements take place and those decisions are made there. And everyone who is directly holding shares in the Indian target because of exchange control restrictions, they will be obligated to vote as per what has been decided at the offshore level. So you need a voting agreement to manage these rights or inter-se agreement between how the shareholders will exercise. These needs to be documented. The other is obviously the put option agreement. We have discussed that in detail. That's basically we capture the economic side of the promoter or the resident shareholders' value and how they derive it. There is a registration rights and coordination agreement. This document essentially is that certain shareholders will have their rights to require the offshore company to register their shares and facilitate their sale to the public pursuant to that registration. So this is what is given in the registration rights agreement. And it also has a coordination aspect because at the end of this whole process, the shareholders who are there, let's say they are investors who have invested in the Indian company, foreign investors who flipped to the offshore company, they are now holding shares in the offshore company. They can have their shares registered and then require the company to facilitate the sale to the public. But when they all are selling, they also require a certain level of coordination amongst the shareholders, because at the end, the entity or the offshore entity is a listed entity. So any such sales should have certain degree of coordination, which is again captured in this coordination agreement. Just a short note on the registration rights. What we have seen, there are two types of such rights. One is demand rights and the other is piggyback rights. Demand rights are essentially where the shareholder can demand this offshore entity to register these shares. So if the shareholder who has the right to demand for registration, and piggyback rights is essentially like a tag where the shareholder can require that in case the company is registering certain shares or shares of some other shareholder, then it can tag along and require the company to also register its shares and facilitate its sale in the public market. So this is the registration rights and coordination agreement. So there are some other documents as well and things you need to be sort of looking into and start documenting. If we were discussing about the pipe investment, so if there's a pipe investment, then there has to be a subscription agreement in context of that pipe investment, documenting how that money would come in and what will be the terms and sort of the rights and structures around it. Then at the India company level, because there have been investors who have been previously there, we would see that the articles of association all will already have certain sort of, let's say, reserve matter rights for typical PE investors are there at the India level. Those would again need to be amended and modified to sort of typically be simplified, because now you want to remove the rights from the Indian level and sort of go to the offshore level. Then there are other areas, because there are securities which are already there in the Indian companies whose terms may require amendment. There will be SEC or whichever, let's say future London sort of liberalizes its regime, which is planning to do so. Singapore liberalizes, which it's planning to do so. So depending upon where the Spak is raised, there will be that particular jurisdiction's sort of listing regime, which would require certain documentation. Like in US SEC, there may be a Form F4 filing currently for registration of securities by a foreign issuer. So there are multiple documents which are involved in a Dspac transaction. This is just a summary of those. Depending upon the structure that you take, one will have to consider this carefully from an Indian exchange control and tax and other areas as well. But yeah, these are something that will normally be there in all sort of SPAC transactions involving an Indian target. With that, Nishchal,
probably thanks for the detailed discussion on the documents. I think we are almost nearing the end of the session, but before that, we can take a few questions from the participants that we have received. One of the question is there a minimum fund size for SPAC? What we have seen is most of the US SPACs are between $200 to $400 million. There are SPACs below $200 million too, but on an average, it's between $200 to $400 million. As per the Gift City SPAC regulations, the discussion paper that has come out, the minimum size of a SPAC has been prescribed at $50 million. So if at all there is an Indian SPAC tomorrow, of minimum $50 million. One of the other important thing for SPACs is SPACs are typically either industry specific or geography specific. So either it could be the SPAC can invest in, let's say, e-mobility startup, or a growth stage company in any jurisdiction in the world, or it can be SPAC will invest in India and it could be any of the businesses in India, right? So it could be either geography focused or industry focused. One of the other question which has come is, are the founders holding Class B shares allowed to vote for the Dspac transaction? At least what we understand based on the prospectuses that we have seen for Cayman SPAC and Delaware SPAC, the founders actually give an undertaking as part of the SPAC documentation that in case the SPAC transaction, the Dspac transaction comes up for vote, they will vote in favor of the Dspac transaction. And the threshold typically is 50%, because that's the threshold which is as per the local company law. So Delaware corporate law and Cayman corporate law prescribed for the purpose of voting in case of a Dspac transaction. One of the other questions that has come up is what happens in a pipe transaction? Is a pipe transaction conditional? At least what we have seen is typically most of the SPACs prefer to acquire businesses which are at least 2 to 3 times the size of the SPAC. So pipe transaction does help in taking care of the contingency with respect to any refunds that need to be made to the public shareholders. But at the same time, the situations what is the pipe money is actually required for the growth business of the target company also. So most of the times we haven't seen the pipe transaction as being conditional to the refund. And it is actually absorbed by the portfolio company for some other purposes. What type of financials should the SPAC target have? Now, this actually varies from geography to geography, but at least the US SPACs, the data suggests the revenue somewhere between $150 million to $1 billion is an appropriate target for SPAC. There have been few companies which have been actually making net losses who have still been SPAC targets. So it varies from again industry to industry, but there was one survey done by one of the top financial firms, and 150 million to $1 billion was the range of annual revenues that the SPAC targets had made. What happens to the dilution due to redemptions, right? So what happens is when redemptions happen, obviously the class A shares and the B shares, the founder shares, which is class B shares, and public shareholder shares, which is class A shares, they have the same voting rights, right? So when redemptions happen, pro rata the voting rights of the founder shares and the public shareholders who have not demanded redemptions, they increase pro rata in the company. And because the voting rights increase, the economic rights also parallelly increase with that. And depending on whether it's a transaction where SPAC is merging with the target or target is merging with the SPAC, they get the shares in the merged entity. So that's another question that has been asked. How do public shareholders bear the cost? I think here the way this works is, as I mentioned, there are 4 instruments: Class A shares, public warrants, private warrants, and Class B shares for founders. If any Dspac transaction doesn't happen, then public shareholders get their full money, and the founders lose their money. So which is the downside for founders? As I mentioned, the upside for founder is by just putting in $25,000, they get 20% stock in the SPAC. But at the same time, if they're not able to identify a good business combination and get it passed and consummated, they lose all their monies which they've invested in founder shares. So that's the downside for the founders in case of a SPAC. Let me just take 1 or 2 questions more before we end this session.
I think, Nishith, there's one question on externalization and the right time for externalization before or after identification of a SPAC. And I think we've been seeing that there are a lot of externalizations which are taking place for Indian companies. The stage of the externalization is extremely important because externalization could result in tax implications. So therefore, if there is no SPAC to acquire the shares, then the externalization may still make sense if you are in early stages. If it is a company which is in late stages, then also externalization is generally a taxable event unless and until the shareholders have a treaty exemption.
Yeah. There is one more question, and maybe this can be the last question. Is target pre-identified before SPAC listing? So as I mentioned, there are 2 listings which happen. One is the SPAC listing, which happens at the time when there is no target that is identified. And in fact, it's a mandatory condition from SEC that you cannot identify a SPAC target before the SPAC goes public, because the disclosure for listing of the SPAC, SPAC does not have any business. Right? second transaction happen where the target company is going to get listed on NASDAQ. That's something called a re-IPO transaction. At that time, all the details of the target need to be submitted to NASDAQ and SEC, including the US GAAP conversion of the Indian accounts, and all those things need to be done. And that is the time when SEC is out 3 to 4 months on the dollar filed with SEC to clear the combination. So this, I think we can now conclude the session. We wanted to thank all of you for taking out time to attend this session, and hope all of you found this interesting and useful. If you have any questions, which have been left unanswered, feel free to write to us at NDA. You can write to us at nda@nishithdesai.com, and we'll be happy to respond to your questions. Thank you.